Hi, very good morning. This is a Delhi High Court judgment. Citation is MGI India Private Limited versus International Design and Engineering Solutions Private Limited. Very interesting judgment, and a lot of disputes may be there in this field. The issue before the Delhi High Court was whether non-solicitation clause or non-hire clause in an agreement can be made enforceable or not. That is the issue. Facts: MGI India Private Limited, I will say it as MGI. International Design and Engineering, I will say it as IDE. So that will be easy. Every time if I say the full name, that will take a lot of time. So MGI entered into a consultancy agreement with IDE. Under the agreement, IDE has to provide certain consultancy services. There was a non-hire clause in the agreement. IDE's case was that MGI promoted another company by name MGI Infra and induced the employees of IDE to leave the services and join MGI Infra, which is in violation of the non-solicitation clause or non-hire clause. Hence, IDI claimed compensation. Matter went to arbitration. Arbitrator held that the negative covenant pertains to period post termination, restricting employees' right to seek employment and or to do business in the same field as the employer. The clause is in restraint of trade and hence it is void. Arbitrator said this clause is not valid, it is void because you are restricting the employees to take up employment or do business. Arbitrator said it is void. This award was challenged by IDE under Section 34 of ANC Act, Arbitration and Conciliation Act, before single judge. Single judge held that the award is directly contrary to judgment of Delhi High Court in Wipro Limited and set aside the award. IDE was permitted to agitate its claim in accordance with law. Then this judgment was challenged by MGI before division bench. There was no stay of the judgment of the single judge, but IDE did not take any fresh steps against the MGI. Since the matter was pending before the division bench for 4 years and no fresh proceedings were initiated by IDE, division bench suggested to the in the court, open court, why don't you bury the hatchet? Matter is over and matter is pending for long years and IDA has not initiated any fresh steps. The councils agreed. Based on this, the division bench passed the order that the view taken by the single judge does not require interference. And the case was closed. Then a review petition was filed by IDE on the ground that the concession was given by the council without the consent of IDE. So they filed affidavits, etc. The council also filed affidavit saying that sorry, the instruction was not given. We ourselves agree. The councils have to be very careful in the court. Review petition was allowed, and the appeal was restored back to the division bench. Delhi High Court held that the issue whether non-solicitation or non-hire clause in the agreement is enforceable or not is no more res integra. This has been decided by Supreme Court in Niranjan Shankar Golikari case and was followed in Gujarat Bottling Company Limited case. Supreme Court held therein, this is the Supreme Court's judgment. I am giving only a portion of it. The rule now is that restraints, whether general or partial, may be good if they are reasonable, and any restraint on the freedom of contract must be shown to be reasonably necessary for the purpose of freedom of trade. A covenant in restraint of trade must be reasonable with reference to the public policy, and it must also be reasonably necessary for the protection of the interest of the covenantee, and regard must be had to the interest of the covenanter. Contracts in restraint of trade are prima facie void, and the onus of proof is on the party supporting the contract to show that the restraint goes no further than is reasonably necessary to protect the interests of the covenantee. And if this onus is discharged, the onus of showing that the restraint is nevertheless injurious to the public is on the party attacking the contract. The court has to decide as a matter of law, 1, whether a contract is or is not in restraint of trade, and 2, whether, if in restraint of trade, whether it is reasonable or not. The court takes a far stricter and less favorable view of covenants entered into between employer and employee than it does of similar covenants between vendor and purchaser or in partnership agreements. And accordingly, a restraint may be reasonable as between employer and employee, which would be reasonable, and accordingly, a restraint may be unreasonable. And accordingly, a restraint may be unreasonable as between employer and employee, which would be reasonable between the vendor and purchaser of a business. So, in this case, there are two companies. It is not between employer and employee. It is between two companies, MGI and IDE. On the above reasoning of Supreme Court, Delhi High Court upheld the judgment of single judge, setting aside the award of arbitrator, stating that arbitrator stated there non-solicitation clause in the agreement is void and unenforceable. So the arbitrator view was found to be incorrect, because the conditions prescribed by Supreme Court must be seen by the arbitrator. Delhi High Court said it is for IDE to initiate fresh steps in accordance with law, lead evidence to demonstrate that the said clause has been violated during the subsistence of the agreement, or that the employees have been induced to resign to form the new company, which is an associate company of the MGI, and thus they are entitled to claim damages. They have to prove all these things to claim the damages. So the appeal of MGI was dismissed by Delhi High Court. Thank you very much. Have a great and wonderful day. Bye.